New Year's Eve, as 1966 became 1967, was clearly an intense night at the Chelsea College of Science and Technology. The night watchmen, including William Barnett, got together at the start of their shift and had some drinks. The case doesn't say how many, but the implication is that they had more than one. About 4 a.m, one of the night watchmen, Whittle, was attacked by an intruder and struck on the head with an iron bar. He was taken for medical treatment, but then returned to work, having been instructed to have x-rays later that day. When he got back to work, the three men had a cup of tea and all immediately started vomiting. They went back to the emergency department at the Chelsea and Kensington hospital, where they were seen by a nurse. Her impression was that they had been drinking to excess and that this might have caused the vomiting. She spoke to a doctor on the phone and, without examining them, he said that they should go home and see their own doctors in the morning. They left, and Barnett died from arsenic poisoning. It seems arsenic had been introduced into the tea, the coroner said, as an act of murder. The question before this court was whether the hospital was liable in negligence for not having treated Mr. Barnett and for having sent him home to his death. The court accepted that the hospital had had a duty of care and that the hospital had failed to discharge that duty by not even examining the men. However, the next question was whether that failure had caused the harm, had caused the death. The evidence suggested that regardless of whether he had been admitted or not, it was too late. Justice Neild found it might be a true assessment of the situation to say that there was no chance of the specific antidote to the poison being administered before the death of the deceased. For those reasons, I find that the plaintiff has failed to establish on the balance of probabilities that the defendant's negligence caused the death of the deceased. This case underscores the significance of causation in negligence law. Even if a party has a duty of care and fails to discharge it, the plaintiff must still show that the harm they have suffered was caused by that breach of duty.